SJC-11517, Commonwealth v. Antwan Carter, and SJC-11518, Commonwealth v. Daniel Pinckney.
Thank you.
Chief Justice Budd, and may it please the court. Too much went wrong in this case for these convictions to stand.
Mr. Nathan, can you talk a little louder? Sorry.
Yes, Your Honor. Too much went wrong in these cases for these convictions to stand, and it's hard to know where to begin, but the obvious place is jury selection. And so just as an outline, I will address jury selection. I'll try to get to prior bad acts as well. Attorney Harwood is going to focus on late discovery and closing. We're both happy to answer any of your questions. As to jury selections, we have black jurors being excluded. We have gay jurors being excluded, at least one gay juror.
Are you sure, counsel? Because I thought I read in the record that nobody was asked, which was appropriate, and it wasn't clear.
Well, sure, Your Honor, and I think you've proposed the most elegant solution to that, which is Robertson, right?
Thank you.
Now we're in real trouble.
Which is when a juror's class is reasonably in dispute, which is the language of Robertson, you simply presume that the juror falls within the suspect classification. And I really do intend to talk about that.
That's okay. That's a good point.
It's an important question, though. But this is a step one case all the way through. And step one is a really low bar. It's a prima facie case, which is a totality of the circumstances inquiry, which I know this court knows. But totality of the circumstances for prima facie means just evidence that's sufficient to draw an inference. It's not a more likely than not test. Using presumption language is really problematic here because it kind of undermines that the Supreme Court's articulation of what prima facie means. But the overarching point is that each individual juror has a right to serve. And the law that this court enunciates has to be shaped to protect those individual rights.
Isn't it must, this is going to be very, I'm not disagreeing with you that this may be a protected group for these purposes, but it's going to be very difficult to do this, isn't it, as a practical matter? Because you don't know if people are in the category or not. You don't know whether past people were in the category. It just seems this is going to be an enormously complicated process when you can't ask.
Sure, Your Honor. And so I'll just reverse the order of my arguments so that we can get right to that. I'm just going to skip the question of whether this is a classification because it appears that we're assuming that this is a cognizable classification under the Bats and Sores protocol. So it's really not that hard. As I said to Justice Seifer, when it's reasonably in dispute, you simply presume under Robertson, and trial counsel anticipated that. I mean, he said, if you're not going to let me, how can I make the showing if you won't let me inquire? But so what he did was...
And you don't want him, you agree with the California approach, right? We shouldn't inquire, right?
So I don't particularly have a problem with it, but it's not the best solution, right?
Okay.
And amici don't particularly have a problem with it either. But it's not the best solution. The best solution is just simply, can counsel point to something based in the record? Not a hunch, something you can articulate. And so here, counsel pointed to a domestic partnership. That doesn't clinch anything, but nor does an Irish last name clinch Catholic religion, right? But Carlton says...
I get the part about the people you're contesting, but this was juror number 100 and blankety blank, right?
202.
202. We don't have any idea whether the first 200 were or were not gay, right?
That's true, Your Honor, but I don't think that's particularly problematic because
if you have to identify an indicia of a pattern, but you have no idea. I mean, it's just a lot easier when you can identify whether someone's in a group or not. Here, I mean, we have no idea.
So I think there's two responses to that. One, pattern is retired, right? We're not looking at that anymore.
I understand, but we have indicia of something, right?
Sure. But so first of all, if you can't point to indicia, well then fine, because it's probably not reasonably in dispute at that point, right? If you can't point to indicia as to why you're making the objection, then probably it's not a good enough objection, and probably it's not reasonable to infer that opposing counsel is discriminating, right? But where you can point to something in the record, like domestic partnership, then that can be enough to inquire. So how does this go? So again, record-based, not a hunch, something on the juror questionnaire, a male juror says my husband, or the reverse. Maybe the juror says, I work at Fenway Health, which is an LGBTQ associated healthcare organization, something like that. Or it can be something else you articulate, particular dress, particular hairstyle, particular speech affect.
I think we have limited time and you have like 9 or 10 issues. I'm really concerned about the racial challenges. So I'd like to probe a little bit here. And you may not know the answer to these statistical issues, but they sort of are raised by the brief. So I guess 3 out of 8 black jurors had been challenged at one point, right? Is that, I'm just looking at your brief, or at least maybe your brother's brief, where we've got some numbers and percentages going on. I'm just trying to, but we don't have any sense of, like, on page 50, I think, of your brother's brief, he says 25% of the black jurors were challenged, I think it was. Do we have any sense of what percentage of non-black jurors were challenged at that time?
No, Your Honor.
So we can't do any statistical comparisons here based on what you've got here, is that right?
I don't think so, but I think there are certain things that we know, and I can point you to those. So the prosecutor here exercised peremptories against at least 7 black jurors, right? So we have 2 that are not noted, and then the first objection is the 3rd black juror, right? And then there are 4 objections to prosecutor strikes that are overruled, and then there's a 5th objection which is sustained. So we have the 2 that are not noted and the 5 that are noted. So 7 of the prosecutors' 24 objections, 24 strikes were against black jurors. That's about 30%. And there ended up being 6 black jurors on this Suffolk County panel. Now the Commonwealth doesn't get credit for number 6 because they tried to keep number 6 off, right? Again, numbers are interesting. They are a tool. They do not satisfy the real inquiry, which is this particular juror being discriminated against? And that's really, really comes to light with Juror Jones, right? And trial counsel begs the judge, I understand about what you're saying about composition. That's not enough here, okay? And he explicitly says to the judge, once you said the composition was enough to insulate that first challenge, I was really concerned, Judge, that this was going to be used as an excuse, and it appears to me that that's what's happening, right? And so, and here with Juror Jones.
The argument is, essentially the argument by trial counsel is, there's no objection to the first 3 black jurors. But 2, okay. And then basically you're saying the Commonwealth decided, okay, we're not going to allow any further black jurors to be put on the jury.
That's trial counsel very explicitly articulated that. He said he's getting cute, Your Honor. And that's what this court warned against in Jones and then again in Sanchez. So, and let's just go through, because the problem in Jones, in Ortega, in Sanchez, and some other cases is the overly focused response of composition cuts everything off at the knees. Right. And in this case, we have 4 objections that are specifically at
That
issue.
was why I was focused on, do we have any statistics about the percentage of non-black jurors that the prosecution is knocking off? Because I understand, it's just, what we have is limited, and I understand the judge keeps saying, look, I've got this many black jurors on the jury, and that's wrong. We understand that, but I'm just trying to understand what else we know about what's going on there.
Okay.
Yeah, so go ahead.
So here's what, so as phrased, non-black jurors, what we know is, as I said, 7 against black jurors, so 17 others that we have to account for. We know that there are objections to three others actually, that we did not raise in the brief, that counsel said person of color. And, that's not a sufficient objection, and I didn't raise it, okay? But the suggestion from the transcript is that these were Hispanic jurors, and then there was a third juror Pena, who was also challenged by the Commonwealth. So of the 24 challenges that the Commonwealth used, it appears that 14 were against non-black jurors. So running through those 4 challenges, Juror Holden, in the judge's response, she twice notes composition. Juror Nicholson, the judge twice notes composition as a reason. And the Commonwealth, in their brief, points to, well, Juror Nicholson, she had been on an acquitting jury. I would just note for comparative juror analysis that the Commonwealth did not challenge a juror, Marciello from West Roxbury, who was also an acquitting juror. Juror Jones, we talked about, reference composition. Juror Crawford, referencing composition. It's clear here that this judge did, as she did in other cases, overly valued composition as a way to cut off the inquiry. That's a step 1 error, and that's reversal. And in Suffolk in particular, composition is the least instructive and the least relevant factor of all these factors that are listed in Sanchez. And what happens is when you do that, the individual black juror loses their right to serve. I already said trial counsel is begging the judge to look at that. And it's worth noting, when the judge finally does inquire as to the very last juror who's seated, and she sort of suggests that maybe it's age, and trial counsel, the prosecutor, immediately goes to age and says, yes, age is the reason. And the judge says, well, why? There are other jurors of that age seated. This doesn't sound good, counsel, and she disallows it. So, what would have happened had the judge inquired earlier when she should have? We've already sort of talked about the gay jurors, but just so we're clear, we're articulating it. The easiest way for this court to get to the classification issue is just on the basis of sex. That's what Bostock says. That's what Windsor says. That's what Obergefell says. But it's also Article 12. And this court actually, in 1979, in a case called Macaulay, suggested that, actually gay jurors is probably a sex issue. So it's...
Isn't the easiest way to deal with this that is beneficial to the juror, criminal defendants, and the Commonwealth to just, as I said in my concurrence in Sanchez and former Chief Justice Gantz indicated he would like to have it addressed in briefing, that when there's a timely objection to a peremptory challenge based on a race or some other improper purpose, that we just say that prong 1 has been met and we go to prong 2 of bats and swords, and that respects the constitutional rights of the juror, that gives the defendant a fairer trial, and the Commonwealth doesn't have yet another first-degree murder case reversed.
Yes, Your Honor. I endorse that wholeheartedly. I endorsed it Monday. I endorse it today. We should eliminate step 1. But even if we don't eliminate step 1, we still prevail under the law as it exists.
Does that solve the problem on the LGBT issue that you're describing? Because we're not going to have to inquire about we're not going to be focused on what anyone else. and sort of, you don't have any of these statistical issues because if you go with the Justice Lowy approach here.
I think for the most, I don't think it 100% solves it, but it goes a really long way to solving it, which is combined with the Robertson presumption, right? Then it's a very quick inquiry. Essentially, are you saying something that is made out at all by the record counsel? Yes, then this is a valid objection. We're going to step 2. And there's nothing further.
And we tell judges to go to step 2 anyway. We don't just tell them that they should go, well, we don't tell them, we beseech them, please go to step 2, no matter what happens on step 1.
Certainly you could do that, Your Honor.
Yeah, we all the way to former Chief Justice Gantz's footnote in ISA back in whatever year that was, 2012, 2013, whenever that was.
Yes, Your Honor, this is what the court has said. Think long and hard before you don't inquire, right? So I endorse that. Yes, let's just go to step 2. Counsel are officers of the court. We assume that they're making their objections in good faith. Let's explore this issue. Let's protect this juror. Let's protect the defendants. Let's get a fair trial. So I'm starting to run out of time, so I really want to move, if I can, to the bad acts issue, and I think I can do it quickly. So there's a steady stream of bad acts in this case, and I can't go through them all. But it's just,
Tell us, so the gun issue, with, why don't you discuss that?
yes, and that was actually my intention. So the Commonwealth introduces Mr. Carter's prior gun possession. It's about 8 months prior to this incident. It's seized. It's still in the Commonwealth's possession at the time of this trial. It definitively could not have been used in this case. So the relevance is really low, and the prejudicial value is really high, right? And so then what does the Commonwealth do with that? Well, they leverage it in closing for an improper purpose. And this is what the prosecutor says. You know what the Hornets do with guns. You know who was responsible for guns for the Hornets. Antwan Carter is the Hornet who's responsible for having access to those guns. That's his role.
Is there other evidence about Mr. Carter's responsibility for guns with the Hornets, or is this is that the basis for that statement by the Commonwealth?
100%. There's no other evidence of Mr. Carter and guns.
Counsel, could you help me on this one? Because you went to the closing argument, but I'm intrigued by this point. For what purpose was it offered at trial?
Knowledge and access to firearms, which is, one of the articulated grounds of relevance that this court has said. McGee is probably the case that says that most clearly.
So in terms of the admission of that, are you conceding that it was relevant?
No. Well, I would say that at the very least, relevance was very low because it was seized and definitively could not be used. And
But it wasn't being offered for purposes of saying this was the gun that was used in this murder. It was being offered for what you just said, knowledge and access to them.
So there's a propensity problem tied up with that, and there's a 403B problem tied up with that, right? Which is where the relevance is quite low and the prejudicial value is extremely high, especially when we get to the point where the prosecutor leverages it in a propensity type manner. So that's, I think, the real problem. But then we also have the crosshairs, right? This is what the trial judge says. Mr. Prosecutor, you're making clear to this jury that Mr. Carter and Mr. Pinckney are, quote unquote, in the crosshairs of law enforcement. I'm going to wrap up. It's not just that they're stopped in each other's company or stopped in the company of Mr. Hills or stopped in a black car. It's that they're stopped by gang officers who, for some reason, need to accompany Mr. Carter's probation officer. It's that they're stopped 5 times by the youth violence strike force.
I get it that there may be way too much of this here, but some of it's clearly permissible.
But trial counsel, this is what trial counsel actually said, Your Honor, which is, yeah, I understand, yes, the cops stopped him, and they're in each other's company, they're in a car. I understand that. What you're doing
there's a
is
lot-
inviting other considerations here.
I mean, I get when I read through this, there's a whole lot of stuff here, and it looks like it may go overboard, but the idea that this is a gang payback and that these guys are gang members, there's a lot of support for that here. I get that there may be way too much of it, but some of it gets in, doesn't it?
So, yes, some of it gets in. Trial counsel was complaining that this is way too overboard, Judge, and this is just painting our guys as dangerous. You, the jurors, should be afraid of them. And then we get to the point where the judge instructs, and I'm over time, but I just want to really encourage the court to compare the prior bad acts instruction in Wordsworth to the prior bad acts instruction in this case. I think this one is broader. I mean, so in Wordsworth, it just says you can't consider it as propensity, but it's relevant to state of mind, motive, or whether he's engaged in aiding and abetting. Wordsworth, that's too broad. Here, the instruction is can't do, it's not propensity, but it's relevant to pattern of conduct, motive, or nature of his relationship with another person, or to explain the circumstances surrounding other evidence. That is so broad as to not be limiting at all. And when we have this kind of explosive gang evidence, and it's tied specifically to gangs,
I don't
it's
mean to
just too
give you a
much.
fastball down the middle, but sometimes pattern is a non-propensity purpose in a case. That can happen. But here, pattern is not why it was admitted, and pattern suggests propensity.
That's exactly right, Your Honor. it's not an MO case. It's not, there's a distinctive type of killing or distinctive type of, operation here. It's a senseless drive-by is what we have here. I'm well over time. Unless the court has further questions, I'm going to turn it over to Attorney Harwood.
Okay, thank you.
Good afternoon, Your Honors. I've never had the honor of being in front of any of the individual justices, and I consider it to be an honor this morning. So I want to join in the arguments that the co-defendant has made as to the jury challenge and the peremptory challenge issue as to both African Americans and as to gay jurors. And I have briefed that issue as well in my briefs. The Commonwealth has not opposed Defendant Pinckney's joining in those arguments, and I would say that they're fully briefed, and I adopt everything that Mr. Nathanson has said. I would point out that one thing not touched upon is where the Commonwealth in its brief is suggesting a remand. Obviously, they aren't that confident of their position on appeal, and this is a case that's 10 years post-jury selection. In Sanchez, this court basically said, look, we've never really seen a remand as a matter of state practice and procedure in this circumstance. And we certainly don't do so now because it's 8 years after the fact. So I only point that out. I do agree with...
Be a bit of a strange remand too, right? The prosecutor is a judge. The judge is retired. I don't know, were you the trial lawyer? I can't...
No, I was not.
Okay, so it's going to be a difficult thing to reconstruct if we did this, right?
Yes.
Yeah.
I also would point out that with respect to the LGBTQ issue, it should be underscored, the judge was of the view, which even the Commonwealth is not of the view, that it was not a protected class. And so she said in the record, well, we don't have to go down this road because, as far as I know, this is not a protected class. We would maintain that there was structural error right from the beginning at this step one of the Batson-Soares issue.
You have any insight on the statistics on black versus white challenges? Because the brief has a lot of detail on the percentage of black jurors that are challenged, but it doesn't provide a comparison. So I don't know if they were challenging white jurors at the same percentage or a much smaller percentage. I just don't know. Do you know the answers to? Because I think it was your brief I read these statistics in, right?
No, it was actually the Commonwealth's brief.
Okay.
I would simply say, as this court has said both in Jones and earlier in Issa, this is a very light burden. And here you have basically objectively qualified jurors who inexplicably are being challenged. You have the defendants, both black, being a member of the targeted class. And you do have, even though I can't cite for you, Judge Cockford.
Just to push back a little bit. So, read a lot of transcripts. You've got some prosecutors that don't challenge anybody, basically, and then you got this group of prosecutors that are very active, knocking people off. And I guess, I feel like the Commonwealth's presentation is not very helpful because I can't compare. If you're going to introduce statistics, I usually like to, have the full picture, but I don't have any statistical picture on white jurors at all, right?
Right, and perhaps they can elaborate on that from the record.
Yeah, no, I understand. I thought it was your brief, but it's his, right? I got you.
But suffice to say, this was not just one challenge of one black juror. That was the third point. We were up to 5, and finally the judge said enough. So that's another factor, the sheer number of challenges that were being advanced. But as to the second point that I wanted to go over, in this case, there were a number of instances of late disclosure of evidence, mid-trial disclosure of material evidence. And one of the main ones that I need to talk about at length is a disclosure of transcripts that were changed in the middle of trial to reflect a different name.
This is the Cody versus Co-D, meaning co-defendant?
Correct.
So now, what happened here? I'm confused by it a little bit.
So what happened here is, at the first 2 trials, there were these awful co-defendant jailhouse calls where the co-defendant is saying, we have to kill her, she's got to be history. At one point, he suggests that certain other people go over and sexually assault her. There are like 5 or 6 of them, and all of those calls the court can access because I've included in my record the transcripts of the calls. In the first 2 trials, the prosecutor, Assistant District Attorney Tressler, didn't even try to get Carter's calls in against Pinckney. And Judge Giles in the first trial, and Judge Giles and Judge Conley in the second trial limited that evidence to Carter only.
Can I ask, is there a Cody in the mix anywhere? Meaning a C-O-D-Y? Is there somebody named Cody that?
Yes.
Who is the Cody that this could possibly apply to?
Well, and it's the subject of a new trial motion, but the Cody to whom this referred was a gentleman named Dennis Parham. And what happened here is, about the 9th day of trial, right in the middle of the trial, on a Friday, the prosecutor gives notice for the first time that Cody, C-O-D-Y, according to Assistant District Attorney Tressler, is Co-D, i.e. a co-defendant. He gives the 48 hours notice, really 1 business day notice, and based on that one change in the transcript, and you can look at Exhibit 00, you see Cody is the new prosecutor on the third trials thing is what appears. And based on that change to Cody, instead of the nickname Cody, Judge Giles
I get
lets
this,
in
I
all
get
of the evidence.
I get the legal significance that it's a joint, suddenly the joint venture is extended. But I'm trying to understand, who is this other person that you say is Cody?
The other person is a gentleman named Dennis Parham.
What is his role in the
This has
case?
been developed in the new trial motion, which when Judge Giles heard about this, she's ordered an evidentiary hearing, and that evidentiary hearing has yet to take place. But basically, the person who was speaking with Carter, Ellis Santos, said, I was not referring to Daniel Pinckney, I was referring to Dennis Parham. Dennis Parham has a nickname, Cody.
Who is Dennis Parham?
He is an uncle of the defendant.
Okay.
And basically, the Assistant District Attorney, Mr. Tressler, we have since gotten emails, this is in my brief, in which he says, Daniel Pinckney, I listened to his calls with LaToya Thomas Dixon. They speak every other day. He has no idea what co-defendant Carter is planning to kill her. And so the problem here is,
And the judge instructs that not to look at the transcripts, but to listen to them. Is that correct? That
Yes, but-
they should make a determination of whether it's Cody or Cody?
right. So even, but 2 points. The significance is not just the transcript, although the jury is looking at just, Co-D. The significance is all this evidence now comes in for the first time. Why, and I would ask the panel to ask the prosecutor, why did they wait all these many months? Why did they wait until the day before they are going to put in these jailhouse calls to give notice of the transcripts? It left the defense unable to go out, try to find witnesses like Ellis Santos, who we've since learned was the person speaking to Carter. There was no opportunity to investigate anything. It was just, here are the transcripts, now it comes in. Judge Giles says, basically in several parts and portions of the transcript, that it's coming in now because Co-D is the co-defendant. Now, the evidence indicated, and it should be crystal clear here, it shouldn't have come in at all because at the time, Carter was incarcerated at Concord, and Parham, by the way, was also incarcerated at Concord. Daniel Pinckney was not in the same jail. He was at the Nashua Street Jail. There is no nexus, and none argued by the Commonwealth, who conspicuously, they don't argue now the Cody transcript. They just say, well, there was a ride in early April, that's a nexus, and then there was a letter on September 19th, 4 or 5 months later. So their nexus, articulated in their brief, is a single ride before both Pinckney and Carter were incarcerated and a telephone call in September. The killing is March 14th. The first call is May 23 or May 31, and then the last call is at the end of July. There is no evidence at all that either of these gentlemen were communicating, nor could they because they were incarcerated in separate prisons. And the only letter, again, is after the fact in September. So that's, according to the law, there was no nexus shown.
We have cases, right, where even though we've got somebody in prison, that the joint venture has continued, right? We have some case law on that. right?
There are cases, and of course, the longer it gets, the more attenuated it gets.
Right.
But here, there is no nexus, and they're not even arguing the Cody transcript anymore, perhaps because of what's come out in the new trial motion now. And the problem is, the only other thing they say is, well, there was evidence of a joint venture earlier. Okay, maybe there was evidence that they could rely upon earlier at the time of the crime, and they cite the defendant's own calls with Dixon Thomas, but with Dixon, but the defendant's calls with his girlfriend, who we now know from Mr. Tressler, they were talking twice a day, those are no nexus to co-defendant's calls. He's talking to his brother, he's talking to Ella Santos. All of these things were excluded in the first two trials, and Mr. Tressler didn't even try to admit them. And that's a principal issue, that it was a surprise, it was something that couldn't be countered on one day's notice, and that was one of several. When Isha Petty identifies the defendant's black car, the first time in the third trial, never before in the prior two. They try to shore up the evidence as to left hand, right hand gun. The fact that basically Carter writes with his left hand, the shooter.
Is that issue a surprise at trial? That does somebody figure out that he's left-handed versus, is that one of these sort of last-minute trial developments, or is it clear all along that he's seen with the gun in his opposite hand?
I would call it a mid-trial. They didn't list these police officers.
No, I understand that, but I'm wondering whether that was a response to something that came out as the trial evolved, as opposed to something where you
No,
feel...
because the evidence was essentially the same in the first two.
Okay.
I mean, here, when you look at these disclosure points, you have a guidepost, because if they're presenting something...
So just let me clarify. So in the first two trials, the issue of him having the gun in his opposite hand is part of those two trials, the first two trials. And so it's, and then as a last-minute issue, suddenly the prosecution has a bunch of cops who are going to testify that they fire their guns with their opposite hand too.
Right.
Okay.
And then, there are a number of others. 2 days before there's testimony from Thomas Dixon, they give notice of telephone calls that defendant had with her saying, keep your mouth shut. Something that had never been done before. And again, it's like 2 days before, oh, here's this, we're going to now submit these calls. And then there were other issues. He plays an identification by Conchetta Martin of Pinckney as the driver of the black car, and she blurts out in the tape, which the prosecutor's staff doesn't properly edit, oh, that's the one who killed my cousin. And he says, oh, the prosecutor says, I'm not happy with my staff, to explain that. So my point is,
that's stricken by the judge, right?
Numerous changes in evidence that were disclosed as you go, but the main one is 2 days, you change the transcript, and now all of this evidence is coming in against Pinckney. The prosecutor, should be asked, why did they wait until the day before for such a sea change in the evidence? The other issue as to bad acts, and I know that's been touched upon. The main thing here is the judge knew that she was dealing with a witness who was a convicted perjurer. She permitted her to testify, but she said as to the bad acts and the gang evidence to the prosecutor, I'll admit this to Bene, but you had better produce other evidence from police witnesses to corroborate each of these gangs and that there's a rivalry. And what happened here is all the evidence that Mr. Nathanson has talked about, it wasn't as to Pinckney, it was like, this didn't happen in the first two trials. She testified Pinckney was the leader of the Hornets. The MySpace page came in over defense objection showing guns, money, and Hornets-related paraphernalia. MAH lettering standing for Mass Avenue Hornets. You know, multiple stops of Pinckney, 5 by the Youth Violence Strike Task Force. Awful names, you know, coming in about the gang names. And my point here is simply this. The judge said, I'll let it in dimene based on your promise, Mr. Prosecutor, that you'll produce independent evidence to corroborate what she's saying. And they called Mr. Diaz, Officer Diaz, and he never established that there was a rival gang, much less that there was a gang that was at war in some way with the Mass Avenue Hornets. So our point is, he didn't deliver on his promise. All of that awful gang evidence came in, which this court has made very clear. You know, all you have to show here is not that it's the prejudice is substantially outweighed under Creighton, just that it is outweighed, that the relevance is outweighed by the prejudice.
What was the year that this case was tried? Quite a while ago, right?
Pardon me, Your Honor?
What year was this case tried?
2010.
Okay, and Creighton is something like 2013 or so, maybe even later than that.
Yeah.
So is there some analysis of why Creighton would apply retroactively to this trial as it relates to weighing probative value and undue prejudice?
Well, we're raising it on direct appeal. And I would have to say, under any standard, this is awful evidence.
Well,
this is prejudicial evidence.
Well, counsel, let me ask you about that point, because there's a lot of it. And usually when the Debene determination by the court is made, it puts the opposing party on alert that if this subsequent evidence doesn't come in, that they jump up and they say, hey, now give the instruction to the jury that they should disregard all of this. What did the defense lawyer do when all of this subsequent evidence, that this corroboration didn't come in? Did they stand up and say, hey, remember you admitted this only to Bene and therefore it should be stricken?
Well, what I would say is counsel for Pinckney was exhausted from objecting so much to so much evidence. I mean, you can look at the transcript. It was like just a war between him and the trial judge. Mm-hmm. And then the instruction comes in, and as Mr. Nathanson says, she says it can't be a substitute for proof of the crime's charge, but then kind of lists everything it can be used for, whether it's pattern, state of mind, etc. So the exception swallows up the whole. It's basically coming in for everything. Mm-hmm. And so that's a problem. And then I just do want to point out, Judge, in the summation, he capitalizes on this gang evidence. He says, 2 defendants, a gang motive, gang retaliation, evil and cowardly. He says he appeals to sympathy. As to the victim, he says, look at Mr. Steele's back. How does a college student who delivers meals for elderly people end up with bullet holes all over his back, dying in Highland Street and Center Street? Gang violence, that's how. He then likens the victim and refers to him as innocent, delivering meals. One witness at one point is talking about the same stuff, and Judge Giles says, well, look, I don't know where you're going with this. There's not an iota of relevance to this. He invokes 2 of the witnesses, Tennille Wilson and Jermaine Davis, as coming forward because they had so much respect for the victim, Cedric Steele. That wasn't what they testified to. And then the Commonwealth concedes. The prosecutor said that the defendant called Dixon Thomas Dixon, at 2:15 to, in effect, set up the crime, when in fact the call wasn't that way at all. It was from her house to the defendant. And they admit that this was a misstatement of evidence. but it was yet another one that the prosecutor made. So lastly, he kept invoking in his summation, we, the people of the Commonwealth, call whatever witness it was. In effect, linking the Commonwealth to the jury. And he did that, I think by my count, 34 times. Like every time he introduced a witness, even though the defense objected, that's what he did. So that's basically the summation. I do say LaToya Thomas Dixon should not have been permitted to testify.
Really, you know, how you can make that argument when you have these other arguments that somebody's not competent to testify, it paints. It's an embarrassing argument. You know what competency is, and you know the concerns and the history of competency, and you know the requirements of competency. I just can't believe it's in your brief.
But as to the Rosado issue, is, and I think it goes to 33E, did this witness have any choice but to inculpate the defendants because she was charged?
That's a viable argument. That's not what you made. Said that she shouldn't be allowed to testify.
Well, I did make the Rosado argument, and I basically say,
understand.
given the circumstances, she was indicted for perjury, the sentencing was still pending, and she likely thought, if I don't inculpate these defendants again, not only will I get a harsh sentencing, she got 2 to 3 years in prison, I might get much more.
I understand the 33E argument.
Okay, thank you.
Thank you very much.
Okay, Attorney O'Sullivan. You're not going to take your whole 40 minutes, are you?
I'll take as much as the court wants me to take.
Okay.
Good morning, and may
We'll
it please
see.
the court. Shane O'Sullivan for the Commonwealth. I first would just briefly like to acknowledge ADA Dave McGowan, who has helped me with this case and would be here but for the pandemic restrictions. The defendant's convictions for the premeditated murder of Cedric Steele, targeted merely because he happened to be on Highland Street that day when the defendant's plan to carry out a killing was consonant with justice and not against the weight of the evidence. I would first like to turn, with the court's permission, to the race-based Batts and Soares objections. The Commonwealth views 4 objections that are really important. There were 4 objections that were overruled, the first of which the defendants articulated the basis of their objection as being a person of color, which is an aggregate category that presents some problems. But then the next 3, the defendants articulated objections based on race. Justice Kafker, I know you had some interest in the percentages and
Yeah, on page 47 of your brief, you point out that 3 out of 8 of the black jurors are challenged. Then I do my own math, and so there's 11 out of some other number are not black, but I don't know how many the Commonwealth has challenged, because 3 out of 8 that's a pretty big percentage. Is the 11 out of 150, or is it out of something comparable to 3 to 8? I'm just trying to get a sense of how vigorous the prosecution was in challenging non-black jurors.
Sure. So I don't recall the 3 out of 8. The Commonwealth's count, and
Right in your brief.
I believe it was at juror 165, which was the first objection here. The Commonwealth had excluded 3 African-American jurors at that time. That was the judge's finding. The Commonwealth had moved 14 total challenges, however, at that point. So
Right, so there are 11 who are not black who've been challenged at that point, right?
By the Commonwealth, correct, yes.
Yeah,
Yes. And the trial judge also noted that there were 10 seated jurors, there were 5 African-American jurors.
Right, that's what I mean. When I say 3 out of 8, 5 have been seated, 3 have been challenged, right?
Correct,
So
yes.
I'm right on the 3 out of 8, right?
Correct.
I'm not
And-
good at math, but that I can do.
And so there would have been 11 out of 16 then would have been the challenges to
No,
non-African.
that can't be right. It's got to be 11 out of, I don't think the math adds up. 3 out of 8 5 have been seated and 3 have been challenged. Do we have others who are, we only have 8 black jurors at this point going through the process, or do we have many others who are not in the mix here?
Well, the record doesn't speak to that. I guess 3 out of 8 would be assuming that the defendants themselves did not challenge any African-American jurors, because we don't know how many. The Commonwealth is exercising their challenges first, then the defendants were exercising their challenges.
Yeah, I'm just trying to get a sense. Do I have any, it looks like the Commonwealth has challenged 3 out of has exercised challenge to 3 out of the 8 black jurors in the mix, but I may be wrong on that. There may be others, but I'm just trying to get a sense. Is the Commonwealth challenging at that percentage? That'd be helpful to you if the Commonwealth is that vigorous in challenging white or non-black, but I don't have any sense of whether they're knocking off non-black jurors at this kind of high percentage or not.
Well, I guess if you do them, I think the math checks out here. If there's 14 total challenges, that means there was 11 challenges to non-African-American jurors by the Commonwealth. If there are 10 total jurors seated, that means there was 5 non-African-American jurors seated.
Yeah, I don't think that, I think we're comparing apples to oranges. I think, again, correct me if I'm wrong. Well, it's not worth belaboring. Go ahead, do your thing. Mm-hmm.
In any event, the challenges used by the Commonwealth, and to provide a comparison to other cases, this court has noted in the past that the number of challenges to the suspect class compared to the challenges, the total number of challenges, is indicative of something. And I would point to Ortega and Jones, where this court noted respectively 3 out of 5 challenges had been used against African Americans, or 5 out of 13 in Jones. Here, it looks out of the Commonwealth's 22 challenges to African American jurors, the record reflects that 6 of those, or to the Commonwealth's 22 challenges to jurors, the record reflects that 6 of those were to African Americans.
But doesn't that then reduce everything to relativity? And isn't that not what we're supposed to be doing here? Because do you concede the point that your brothers were making, that the judge relying on composition doesn't answer the question? And if there's a properly raised challenge to the prosecutor trying to knock out somebody, it doesn't matter if there were 11 black people sitting in the pool at that point. It just doesn't matter. Do you concede that?
I would concede that certainly it is not the only consideration, and I would concede that certainly it is an individual consideration, juror by juror. However, I do think that the numbers can be very instructive of whether this particular challenge is discriminatory or not. If the prosecutor has not had a history of discriminating jurors of one class over those of another, I would say that is instructive of what is the basis for the current challenge. And in this case, where at any point in these challenges, between half and a third of the seated jury were African American, and when the prosecutor was not using a large percentage of his challenges on African American jurors, those were appropriate factors. I believe they are appropriate factors under Ortega and Jones and Robertson for the judge to make the determination. And those cases also say that not one factor is required, not all factors must be considered. The judge has to take in the totality of the circumstances. And again, that trial judge is the one sitting on the ground floor, best able to make that determination in the moment. So,
but didn't Sanchez have the exact, in follow-up to Justice George's question, Sanchez had 5 black jurors seated already. And we still held exactly that can't be, and that's all you've got here. That's the only defense you have to their challenge, which is the number. And in Sanchez, particularly the First Circuit, was vigorously, pointed out all the problems with that analysis.
Well, I would not agree that the seated jurors were the only factor. The trial judge,
Well, that's the only thing the trial judge mentions, right? She just stops the inquiry by saying there are 5 black jurors on seated here, or in case 3, I guess, at that point.
I don't agree with that. She does use that as a factor. She certainly notes the composition of the seated jury, but she also states explicitly at times that she is taking note of the race and gender of the Commonwealth's challenges. So in addition to the seated jury, she is also considering, I believe the record supports it, she's also considering the composition of the Commonwealth's challenges. So I don't think it's analogous to the cases where the judge is only relying on the seated jury. She is clearly considering that other proper factor of the composition of the Commonwealth's challenges. And she articulates that. She says, I'm taking note of the race and gender of the Commonwealth's challenges. And she notes at times, with juror 165, she says, she breaks down the number of African-American jurors, male and female, that have been challenged thus far by the Commonwealth. So she is taking into consideration
What
that
does she
additional
do
factor.
then? I thought she just says the last two were not black, they were white. Does she say, that, okay, at this point, the Commonwealth has struck, has challenged this many white jurors and this many black jurors? Again, I'm not sure that's good stuff, but she doesn't articulate that in the transcript, does she? She just says she's keeping track somehow.
She does articulate, I'm sorry, I didn't mean
No,
to
go
interrupt.
ahead, go ahead.
She articulates both of those things. She refutes the defendant's assertion that the last 3 jurors challenged were African-American. She says, no, the last 2 jurors were white females. But then she also does note the number of African-American jurors by both, I think, male and female. I think she breaks it down, that have been challenged up until that point. And then she makes later in the
But
findings.
does she talk about the number of white jurors that have been challenged? She seems to be saying, okay, there are 3 black jurors seated. Does she make the point that that the prosecution is doing the exact same thing to white jurors? She isn't doing that, is she?
She does not articulate the number of jurors of other races that the prosecutor has. She doesn't put that on the record. She notes that she's keeping track of it. She notes the number of African-American jurors that the prosecutor has challenged up until that point, at various points when she makes these findings. But she does not indicate the number of.
But so how do we, again, given the case law, how do we save your case here? Because it looks like this is like Sanchez and like Jones and like Ortega. I just help distinguish it, because you may be subtler than I am, and I was looking for some statistical guidance that would indicate to me that the prosecution is treating everyone alike, but I don't have that. I just have this, all I have is Jones, Ortega, and Sanchez. Tell me why this is different from them.
Sure. Well, I think the most important thing is the consideration of multiple factors, not just the composition. If she had just relied, if the trial judge had solely relied on the composition of the seated jury.
That would be very useful if you could tell me how she considered other factors with a reference to the transcript or the record somewhere, because you're saying she's keeping track, but that doesn't help me any. You're not providing any basis for saying that she considered anything else, are you?
Well, her words, and that she does enumerate, look, it may have been better practice for in the moment to have said, this is the number of African-American jurors that have been challenged, this is the number of Caucasian jurors that have been challenged, so on and so forth. She didn't go into that much detail, but it's an abuse of discretion standard.
But she says the opposite. She says, I don't find there's a pattern because there are 3 black jurors seated. And we know in Sanchez, with 5 black jurors seated, that's wrong. And we want to give everyone a chance. And we're trying to rid the challenge process of any consideration of race. And that means it has to be colorblind from the beginning of the process to the end of the process, right?
Yes, but I would disagree that the judge relied solely on that composition of the seated jurors.
Help me out. Show me something she did besides you saying she kept track. Because keeping track could also just mean I've kept track. There are 3 black jurors seated and 5 black jurors excluded, challenged. But that doesn't give me anything more, does it?
I think it does give you something more. I think comparing it to the number of Commonwealth challenges in the totality show that, and I make this point in the brief, look, we don't know the numbers compared to other races. That was not placed into the record, unfortunately. But what we do know is that at a minimum, African-American jurors were being seated on the jury at a rate that exceeded the rate that the Commonwealth was excluding African-American jurors. So I think that's some indication here that they were not acting discriminatorily.
Is that right, even from your own math? That they were 3 black jurors have been suited and 5 have been challenged. So even under your statistics, that's not.
No, Your Honor, it was the other way. At 165, 5 black jurors had been seated, only 3 had been challenged.
Okay, I got you.
And that continued throughout where, again, out of 14 seated jurors, 5 were African American, so that was a little over a third. This is the final challenge. And the Commonwealth had excluded 6 African American jurors, but they'd used 22 challenges, which is slightly over 25%, 26, 27%. So at a minimum, we know that African American jurors were being seated at a rate that exceeded what the Commonwealth was excluding them. I think that's also some indication that the court can use to show that the trial judge's decision here was justified.
Any case that says that's good enough for government work?
Well, Your Honor, I think that when you look at Ortega and Jones and the factors, and the fact that none of the factors are required, and that it's not a list of comprehensive factors either, that the court can consider, the trial judge can consider all the relevant circumstances. I would submit that this trial judge, based on her words and actions during these challenges, was considering this holistically and looking at not only the composition of the seated jury, but also the number of Commonwealth challenges. She also was presumably aware of the defendant's race because that was raised in the context of the Batson Soares objections as well.
The defendant is black, correct?
Correct.
And is the victim black as well?
I don't know what the victim's, I would imagine the victim's family and the victim would have classified himself as African American or black, yes, Your Honor. I don't know if they had other heritage or what their exact, what they would say, but I think that would have been reasonable to assume.
I think what we're trying to get at is when we're seeing whether there's other factors, because I think the composition of the jury, as Justice Georges has mentioned in our case law cautions, it's not that you have to ignore it, but you got to be careful, and it's way down the list. So what else did she consider? And you're saying that she kept track of the other jurors, maybe even I don't know if she said she kept track of the race and gender of other jurors, or whether you think that's implicit in what she said. But the question is that type of statement something that we can consider if we don't know anything about what she kept track of? No, I mean, I don't, that's the question.
I would submit that it is, Your Honor, and the reason why I also think that there's support for it in this is that she not only says that she's keeping track of these numbers, but again, at various times, she notes the numbers at least related to African Americans. Again, she does not say, additionally, the number of Caucasians or Hispanics, and maybe that would have been preferable for her to give a complete assessment at each challenge. But she at least keeps track and notes that the exact numbers of African Americans. So I also think that's some indication that she really was keeping track of the Commonwealth's challenges here. because at various times throughout these challenges, she does make notation of that into the record. And so this is not a case where solely that factor of the seated jury was considered. I really feel strongly that the transcript
And
shows.
you can say that even though this is the same trial judge in 2 other cases. So her practice in the other cases is likely to be the same. It's the same time period. I mean, I don't have evidence to this, but I mean, you're asking us to read in something that wasn't expressed. But we also have the problem, which is that she's also the trial judge in these 2 other cases where we said that wasn't enough, right?
That's correct, Your Honor. I like to, I think there's 2 things I'd like to respond to there. The first is that, I don't think that I'm asking you to read into her words. I do think it's explicit. I think she does say that she's keeping track of this. And the second is that no matter what this judge was, found to have done or to have not done in prior cases, I'm basing my argument here based on the words that are in this transcript,
I got you.
which is,
Which is what you're supposed to do. I'm not questioning that. There's some other problems in this case. I'd like to, there's just a huge amount of sort of bad act evidence here. Why don't we start with, what's the point of the other gun? We know it's not the gun here. It's been seized. Isn't this really potentially quite prejudicial? And then the compounding the problem, we've got the closing where they say he's their armaments guy. Is there other basis for that he's the guy who got them guns?
Your Honor, I would say that the discretionary decision to admit that firearm evidence allowed for the inference that Mr. Carter had knowledge of firearms, and the instruction to the jury.
And he's the gang member gun guy? That statement in the closing? That seems really, that's quite a leap, isn't it?
The trial judge found that it was a reasonable inference that Mr. Carter had retrieved the weapon in question.
That's different from being the Hornets gang gun guy, isn't it? That takes it to another level, doesn't it?
And perhaps if that comment or characterization, towed the line, I would suggest that the main point that was made was that based off the GPS evidence, Mr. Carter was seen to have very briefly, I believe it was 1 or 2 minutes, stopped back at his home just.
Okay, so let me move then to the March 11th shooting, which may have absolutely nothing to do with this, right? We know, we've got all kinds of testimony that this is in response to the shooting of, what's his name, Hills?
Mr. Hills, correct.
So why do we have to have, what is the point of this March 11th incident? And isn't that, again, just its relevancy is minimal, its potential prejudice is high. What's that doing in here?
And Your Honor, if I could, with the
And again, these are
permission,
questions, don't, push back.
push that aside very briefly. That information was, I would first note, was used only minimally in closing. The prosecutor said, we know from Mr. Chris McCarthy, the witness that testified to that there are problems up there. That was his only mention of it. And the reason, or articulated reason for that being admitted was to show that there were hostilities in the area at that time.
But we have a lot of, we have a specific connection. Okay, this is payback for Hills. And by the way, I don't disagree that some gang evidence goes in here. I disagree with the defense counsel that none of it comes in, but there's just so much of it. It's just like, goes on and on. And
there was instructions, I think, I think the trial judge did a good job of instructing to mitigate and focus the jury's purpose on a lot of this information. To go to the park shooting, for instance, the instruction there was that there was no evidence to connect the defendants to that particular shooting. So that potentially ameliorated any prejudice of the jurors using it for the wrong reason or inferring that the defendants were involved. They were instructed that it was only for the nature of the hostilities in the area. There's no evidence that the defendants were involved with that. Going to the firearm, because you raised that, the jury was instructed that that evidence was only admitted to show the defendant's familiarity with firearms. They were instructed very clearly as to the limited purpose that that evidence was offered. They were cautioned as to the misuse of the gang evidence, that only purpose for that evidence was as to the defendant's state of mind, and they were cautioned as to the gang evidence.
Well, it's being part of the joint venture, right? It's also being allowed in on that ground, is that right?
Yes, and but I suggest they're kind of one and the same. The state of mind to form the motive and or to form the joint venture was the instruction, and the joint venture, I think, was really the most important reason why it was admitted. It was really important to know because Mr. Pinckney, again, essentially orders Mr. Carter to commit this killing, says, go hit anybody is, I think, the words that he uses. LaToya Thomas Dixon testified that Mr. Pinckney was the leader of this gang and that there was evidence that both of them were involved in it. So I think it was really important for the jury to know the relationship of these two parties within the gang and with each other within the gang.
What do you say to counsel's argument that there were some dots to be connected in the way that this evidence was admitted to Benet? There were some dots to be connected, and those dots were never connected by a competent witness down the road. Because you keep mentioning all of this because it was critical to, I guess, the Commonwealth's theory. What do you say to that?
Your Honor, I see the dots as having been connected. The Commonwealth provided, ample evidence that these, through MySpace pages, witness testimony, that these paraphernalia found in the jail, that these witnesses were associated with this gang. Ms. LaToya Thomas Dixon testified that there were discussions about retaliation between these two individuals, that the retaliation was going to be carried out on someone from the Highland Street area. That's the exact area where these defendants traveled to. And the motive, in this case, it was somewhat different than I think we see in a lot of gang cases where it's a gang-on-gang crime. These defendants, their motive for retaliation was they wanted to retaliate against anyone who was from the area. It essentially appears like they wanted to send a message to people in that neighborhood by as in Mr. Pinckney's words, hitting anybody. So I would suggest the dots were all connected, that their membership in the gang as it went to their joint venture, why they would commit this together, why Mr. Carter would follow Mr. Pinckney's instructions, and that it was retaliatory in the sense that they wanted to send a message to the people in this area. I think all those dots were connected.
Can we talk about another category when it's talking about Mr. Carter? Was there ever any notion from Mr. Carter that I didn't shoot this gun because I'm left-handed?
Not for Mr. Carter specifically. It was raised in one of the previous trials. In this trial, it was first raised in the cross-examination of Mr. Smith, who was the older gentleman who was helping the victim try to get into his car. That happened on the November 12th date of trial, which was one of the earlier dates of trial, and he is cross-examined by one of the defense counsels as to the hand in which he saw the gun, and that it was in his right hand. So at that point, I would say the defendants had essentially put the court and the prosecutor on notice that this potentially was going to be an issue, the hand in which the gun was in. I don't know that it was ever raised by Mr. Carter in his interview. I don't believe it was.
Okay.
In fact, I think it was not, because I believe that was one of the defendant's arguments in this case, was that a bowed-in type argument that the officer should have taken better note as to the hand which Mr. Carter wrote with when they interviewed him. So
You want to address Cody? It sounds kind of far-fetched that the defendant is referring to his co-defendant as a Cody. And does that really pop up at the last second with this transcript change, the way they're describing it?
Sure, Your Honor. First, I would say on the issue of CODY versus co/D, that is an issue in the motion for new trial. And I would just, without getting into it too much, I would say that that is a contested issue. I would say that Commonwealth hand over a lot of discovery to defense counsels on Mr. Dennis Parham. They have an affidavit from someone that says that he was referred to as Cody, but I would say that's still very contested.
Does the transcript really get changed during the trial? Is that
Well-
the first time it happens, and then they give it to the defense counsel in the midst of trial, and then the shifting of, so that, because that's very damaging stuff. Carter's phone call that's really harmful stuff, that he wants to kill the witness. And then at the middle of trial, Pinckney's got to deal with that against himself for the first time.
Sure, I would say the record reflects, Your Honor, that that transcript was provided 4 days prior to the date it was used. The Commonwealth would acknowledge that transcript should be provided adequately in advance of when it's used.
And doesn't that present him with some serious problems to deal with?
Well, Your Honor, he doesn't ask for a continuance, and I think the most important aspect is the judge's instruction, and that's what I would emphasize here, is the judge very clearly, and I have a direct quote because I think it's so important. I remind you and admonish you strongly that it is what you yourselves hear on this CD that counts, not what's in this transcript. And so with that instruction, I would submit that the defendant was free to argue whatever translation or interpretation that he wished. The transcript was only used as an aid. It was not admitted as an exhibit. The trial judge did not have the benefit of this court's decision in the Portillo case because it was 2 years prior to that coming out. So I think the trial judge followed the law the best that she could and gave a very strong instruction that still provided the defendant the opportunity to make whatever argument about what was being said on that transcript that he wanted to make. In regards to the co-venture statements themselves being admitted, I know that's something that was raised. There was ample evidence of a joint venture here. The discussion of the crime prior to committing it, traveling together. Mr. Pinckney assisted Mr. Carter in fleeing, moved the automobile prior to the shooting to another street to assist in the escape. Mr. Pinckney asked Ms. LaToya Thomas-Dixon to take the gun before she even hears the shots being fired. So there was clearly some sort of an agreement here. Again, they fled together. They both engaged in efforts to try to hide the crime, consciousness of guilt evidence. And as to the statement itself and it coming while Mr. Carter was incarcerated, look, the Commonwealth also points to evidence that these two defendants were still in communication even after this crime. They were seen together 1 month later driving around. Mr. Carter tried to send Mr. Pinckney a letter in the jail. But I don't think that the case law necessitates that they be in communication with each other or that they have agreement as to how they're going to conceal the crime. I would suggest that that statement comes in against Mr. Pinckney, whether he knew about it or not. They were not under arrest for this crime at the time. The statement was designed to conceal the crime, and there was ample evidence of joint venture even outside of that, prior to and outside of that statement that was admitted. So for all those reasons, I would submit the trial judge properly admitted that statement against both of the co-venturers. I can there's a few other points I could continue to make, but I
You've got
don't know if there's
time.
any aspects that the court would like me to highlight or,
Nope, go ahead.
okay. I would like to just briefly touch on the Batson Soares challenge on the basis of sexual orientation. The Commonwealth is in full agreement that sexual orientation should be a protected class under our Articles of Rights. However, in this case, Juror 176, no objection was made. As to Juror 202, the objection that was made, I think the best evidence here is defense counsel admitted when he made the objection, he was asked what he was basing it on. He said he was just speculating. The only information was that this juror had a domestic
So
partner.
how is this going to work in the real world? If we don't adopt Justice Lowy's variation of this, how do we determine whether there's an indicia of this when we really don't know what, there were 200 people before this. We have no idea whether they're gay or not, or LGBT or not, right? We just have no clue. How's this going to work? I mean, I understand if we adopt Justice Lowy's position, we could avoid this problem. If you raise the issue, then provide a reason. But if we use our existing law, which requires some indicia of discriminatory challenges, how do we do that here without knowing anything? And I take it you agree with the defense counsel, we shouldn't ask, because it puts people, we shouldn't be asking people's sexual orientation during jury selection.
Correct, yeah, yes, that's in the Commonwealth's brief.
So how will this work? Because, I mean, if you want us to go here, because we have agreement that we should adopt this, but we don't have much guidance on how this should work.
Sure, so the Commonwealth had cited to a few cases, one from the appeals court here, there's another from Nevada, another in the Ninth Circuit, that where it arises, if the juror, like did in the LaCoy case, if the juror states that he or she is gay, or if the juror uses, let's say, another example is a gendered pronoun to describe their partner, if it arises and the juror volunteers it, then it's a factor that can be considered. Now, I
So
understand the court.
just to push this one step further. So if a juror says, I have a domestic partner, and the defense counsel or the Commonwealth, if the defense objection says, objection, Your Honor, they're targeting sexual orientation. Again, Justice Lowy's thing works neatly. You just provide the reason. But if we're sticking to stage one, what is the judge supposed to do?
Well, I think the judge can do exactly what the judge did in this case, is find that there's no prima facie evidence, because
No, the judge didn't do that here. The judge did the opposite. The judge said it's not a protected class.
Sure. Well, yeah, that's a fair correction, yes. What I would suggest the judge should do is find that a prima facie case hasn't been established. And what I would analogize it to.
But how does the judge make that determination? I mean, like in your case here, you say the judge is keeping track of race. The judge can sort of do that maybe, but the judge can't keep track of sexual orientation.
Correct, they can't. And what I would analogize it to is religion, right? Religion is a protected class. It would, of course, be improper to strike a juror based solely on their religion, but it's not something that's always, or sometimes ever outwardly apparent, just like sexual orientation. Whereas race, ethnicity, sometimes from name or skin color can be.
Well, I mean, again, that's a good example. That's the closest thing I could think of, but we tend to then look at names and sort of, origin of names and sort of make this kind of rough guesswork, although I'm not sure, again, how reliable that is or whether it's just completely unreliable. But it seems like it will be even harder when we're dealing with sexual orientation.
And what I would say, I would suggest the court to discourage that kind of rough guesswork, because I think that's what the trial judge was refusing to engage in this case. And I point to, again, bring back to the religion analogy, the Carlton case, which Attorney Nathanson cited in Robertson, acknowledges that a surname can indicate national origin. It's not necessarily instructive of religion. So I think there is some precedent for the court to say, look, unless it is unambiguously apparent, we're not going to allow inquiry in it, and it does not meet the prima facie burden. Because I think the alternative, I guess what I would be concerned about is if every objection requires a reason, it is essentially doing away with peremptory challenges. And I think there's still a very good reason why we have peremptory challenges, and they can be very useful for both defendants and prosecutors in challenging jurors for reasons that, whether it's a certain demeanor that the witness has, or something that maybe they appear to be lacking interest, or something that might not, there might not be agreement with the trial judge on a for-cause challenge, but the litigant firmly believes in it, could maybe still be accepted as a peremptory. And I think allowing defendants and prosecutors to have jurors that they think will fairly decide the case is good policy. So I guess what I would just suggest to the court is there may be instances where the prima facie case just hasn't been met on what was presented, because in the instance of sexual orientation, the juror just did not volunteer it. I see that my time is expiring unless there are further questions.
I think we're all set.
Thank you.
Court all rise. All persons having anything further to do before the Honorable Justices of the Supreme Court, now sitting in Boston, Judicial Commonwealth. I turn to the court, sitting in this court, is now adjourned. I'll take the Commonwealth.